Hello friends, in the series on the income tax cases, today we will discuss the case of Shrimati Maris Joseph versus Deputy Commissioner of Income Tax, International Taxation. This case has been reported in 101 ITAT Tribunal at page number 629 and the matter has been decided by COCHIN ITAT. The date of the judgment is 2nd January 2023. And this matter relates to the assessment year 15-16 and the matter is related to the section 54F exemption. Section 54F exemption says that if an assessee has any long-term capital gain other than the gain on the residential property, then he can claim the exemption by investing the sale proceeds into a residential property, and that residential property should be in India. Earlier, this investment was not compulsorily to be made in India, but it has been seen that the assessees were misusing the provision and making huge investments out of India. That is why in India word was inserted. There is a condition in the form of proviso that on the date of the sale of the land and building or any property on which the assessee is claiming exemption, on that date the assessee should not have more than one residential property. But in that proviso, there is not a condition that residential property must be in India, meaning thereby that the condition of having not more than one residential property will not include the properties which are owned by the assessee outside India. This was the main crux of this case. In this case, when the assessee claimed the exemption, the assessee claimed exemption on the investment in a property. But during the assessment proceedings, the assessing officer gave the exemption, but not on this property, on some other property in which the husband of the assessee was joint owner, due to which some exemption got reduced in the case of the assessee. That is why the assessee was before the CIT appeal. But when this matter was before the CIT appeal noticed that the assessee was having some two residential properties in USA, and he said that the assessee has breached the proviso of section 54. That is why the whole exemption is not available to the assessee and initiated the penalty proceedings. Now the matter was before ITAT. The ITAT said that in the main section, there is a condition that the investment in the new residential property should be made in India. But this in India word is not there in the proviso. So if the assessee is having more than one residential property outside India, that will not be counted in calculating the number of one property which is there in the proviso to section 54F. Friends, although in this case, this interpretation has been taken by the COCHIN ITAT, and I think that the department will go to the High Court, and some different type of interpretation can also come from the High Court. This is a very risky judgment as far as the assessee is concerned. It was the point of the assessee that the purpose of section 54F is to promote the investment in the residential property in India. But if the assessee has residential property outside India and the exemption will be denied, then the basic purpose of exemption will be defeated. But this argument can be taken otherwise also, because if the assessee will be having surplus funds, then he will invest outside India, and that investment outside India into the residential property will not be counted for calculating the number of the properties. So assessee will be getting the undue benefit. But the ITAT has gone very strict sense according to the words of the legislature, or you can say that according to the words used in section 54F, and allowed the appeal of the assessee and gave the exemption under section 54F, even if the assessee was having two residential properties outside India, and in this case the assessee was having the property in USA. This is a very technical case. At the end of this video, once again I am repeating the name of the case. The name of the case is Shrimati Maris Joseph versus Deputy Commissioner of Income Tax International Taxation, and this case has been reported in 101 ITAT Tribunal at page number 629. The date of the judgment is 2nd January 2023. Thank you, friends.